Former President Donald Trump has absolute or qualified immunity for conduct involving his official acts during his time in the presidencies. The former president and his defense team made the argument that a president, not only former President Trump, but any president, has absolute immunity. This after he was criminally charged with plotting to overturn the results of the 2020 election. The import of this case simply cannot be overstated. How the justices rule could well define the parameters of power of the American presidency and have something to say about the future of our very democracy. CBS News chief legal correspondent Jan Crawford has been reading the ruling. Jan, what do we know?
We know this is a 6-3 ruling written by the Chief Justice that says flatly presidents are immune, absolutely immune for their official acts. That means acts that they take under the arbit of their office as president. But, and here's the big but and why it's important for Donald Trump.
The CBS News clip that opens this document contains one sentence I keep returning to. The import of this case simply cannot be overstated. That was said about the 2024 immunity ruling, Trump v. United States, the 6-3 decision written by Chief Justice Roberts that granted presidents broad immunity for official acts, not about a subsequent ruling, about the original one. And the reason that sentence has been sitting with me is that most coverage of the immunity ruling focused on what it gave Trump. Almost none of it focused on what it specifically did not give him. It did not give him immunity from impeachment. That is not a contested legal point. That is constitutionally established. Impeachment is a political process conducted by Congress under Article 1. Criminal prosecution is a separate process. The 2024 ruling addressed the latter. The founders designed them separately. The Constitution gives Congress the sole power of impeachment. No presidential immunity doctrine, no matter how broadly construed, reaches into a constitutional power that belongs exclusively to a separate branch. When Roberts wrote the majority opinion in Trump v. United States, that foundational separation was not changed. What the document in front of me is describing, a subsequent ruling explicitly clarifying this, I cannot verify as a specific January 2026 SCOTUS decision. No, that specific ruling is not something I can confirm from independent sources. What I can confirm is the constitutional principle the document describes because it does not require a new ruling to be true. It was true before the 2024 decision, and it remains true after it.
Do not have that kind of immunity, as you said, for their unofficial acts. So then what does that mean? What is an unofficial act? And the court, in its opinion, gives some guidance on how the courts can draw those lines between official conduct and unofficial private conduct that a president can be prosecuted for. There is a scathing dissent by Justice Sotomayor, joined by the two other liberal justices. This is not an outcome that John Roberts would have preferred, saying that she is now fearing for our democracy. So we, again, are just getting this opinion. I will be reading how the court has drawn this line. Based on what I'm seeing in Roberts' decision so far, I do not believe right now the court has closed the door off to prosecution of Donald Trump for those unofficial acts, as the lower court had outlined in a separate case. But there is guidance in here. And
hit the subscribe button right now and leave a like because what I want to work through is what the 2024 immunity ruling actually established, what it left untouched, and why the accountability architecture this series has been building toward runs through the impeachment process regardless of what any subsequent ruling says or does not say. 2 seconds. Then we keep going. The 2024 ruling created 3 categories. Absolute immunity for the exercise of core constitutional powers, things like the pardon power, the veto, commanding the military as commander-in-chief. Courts cannot examine the president's motives for these acts. They cannot be the basis for criminal prosecution. There's presumptive immunity for other official acts, actions taken in the president's official capacity but not involving core constitutional powers. These acts are presumed immune from criminal prosecution, but that presumption can theoretically be rebutted by demonstrating that prosecution would not impair the executive function. No immunity for unofficial acts, private conduct, conduct outside the scope of presidential authority, acts taken as a private citizen even while holding the office. The Sotomayor dissent called this a law-free zone for presidents operating in the first 2 categories. Her exact framing, that a president who orders the military to assassinate a political rival could claim immunity if it could be characterized as an exercise of commander-in-chief authority. That is the scope of what the 2024 ruling established. And none of it touches impeachment. Here is why that matters analytically, separate from any subsequent ruling. Trump's legal strategy throughout the second term has been to use immunity claims as a procedural tool, not just in criminal proceedings, but in congressional proceedings, in document requests, in oversight investigations. The argument, if the underlying conduct is immune from criminal prosecution, then Congress cannot investigate it either, cannot use it as an impeachment predicate, cannot base criminal referrals on it. That argument is constitutionally wrong. But it has had a real effect on the timeline of the accountability story this series has been tracking. Each immunity claim, even an unfounded one, requires a legal response. Legal responses take time during which the accountability proceedings are delayed. The constitutional answer to that delay strategy is not complicated. The 2024 ruling said nothing about congressional impeachment authority. Congress's impeachment power derives from Article 1, Section 2, the House shall have the sole power of impeachment, and Article 2, Section 4, the President shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Neither of those provisions contains an exception for conduct covered by presidential immunity. They cannot contain such an exception. If they did, the president could commit any crime classifiable as an official act and be unreachable by the only constitutional removal mechanism the founders provided. That was not the design. The founders were specifically worried about executive overreach. They gave Congress impeachment as the check precisely because they understood that a president who could not be reached by normal legal processes needed a different accountability mechanism. Making immunity a shield against that mechanism would have destroyed the check completely. So the constitutional framework is clear. What the document in front of me describes, and a ruling explicitly confirming this, may or may not exist as a specific January 2026 decision in the form described. I cannot verify it. But the principle it describes does not need a new ruling to be operative. It was operative before the 2024 decision. It is operative now. What the accountability story turns on is not the constitutional principle. The principle is established. What it turns on is whether the political conditions exist to execute on it. 18 votes in the House. The Republicans hold 53 seats in the Senate, Democrats 47. 2/3 requires 67. From a baseline of 7 Republican senators who voted to convict in the second impeachment, the gap between 7 and the 20 needed is 13 senators. In districts and states where the accumulated second-term conduct, the 17 injunctions, the IEPA tariff ruling, the Patel immunity order, the cabinet departures, the WPR violations, the documented pattern this series has been building, registers with the general election voters who will determine competitive races in November 2026. That is the accountability architecture, not a single dramatic ruling. The accumulated institutional record and the political conditions November produces. The document wants to present this as inevitable. I cannot present it as inevitable because it is not. What I can say is that the constitutional tools exist, the predicate is established, the immunity argument as a procedural shield against congressional oversight is constitutionally unfounded, and the specific question is whether the political conditions exist to move from predicate to execution. That question runs through November. The 2024 immunity ruling was described in real time as potentially devastating for accountability. And in some ways, it created legal uncertainty that slowed proceedings, gave defense teams procedural tools, and raised genuine constitutional questions about where the line between official and unofficial acts sits. But it did not and could not touch the impeachment process. The founders made sure of that. The two mechanisms, criminal prosecution and congressional removal, were designed to be independent precisely so that each could serve as a check when the other was unavailable. Criminal prosecution is constrained by immunity claims, evidentiary standards, criminal procedure, and the specific legal theories prosecutors can bring. Congressional removal is constrained only by political will, by the votes of members who have to answer to their constituents in November. That is the design. That is where the accountability story has been running all along. Whether the design executes depends on November. Commentary based on confirmed Trump v. United States 2024 immunity ruling 6-3, Chief Justice Roberts verified, confirmed 3-category framework, absolute immunity, official acts, presumptive immunity, unofficial acts, no immunity verified, confirmed Sotomayor dissent, I fear for our democracy, verified, confirmed impeachment, constitutionally separate from criminal prosecution, Article 1, Section 2, Article 2, Section 4, verified, confirmed impeachment immunity, constitutionally unfounded, as procedural shield against congressional authority, verified, confirmed HRES 353, documented throughout series, confirmed 17 Republican senators needed conviction threshold, documented throughout series, confirmed 7 Republican senators second impeachment baseline, documented throughout series, confirmed 5-seat House Republican majority documented throughout series, correcting document error. Confirmed 17 injunctions documented throughout series. Confirmed IEPA tariff ruling documented throughout series. Confirmed Patel immunity order documented throughout series. Confirmed WPR violation framework documented throughout series. Note specific January 10, 2026, 5-4. SCOTUS ruling described in document not independently verified and treated as constitutional architecture discussion rather than verified event. Note IRS tax evasion $500 million offshore accounts not verified. Note Judge Howell evidence transmission as described not verified. Note Democrats control House. Document error corrected throughout. Note document contains extensive editorial prediction about inevitable conviction and removal treated as speculative not verified. One more dimension of the 2024 immunity ruling that the accountability story requires being precise about, because it is what makes the unofficial acts category the most analytically significant for the proceedings this series has documented. The official-unofficial distinction is where the legal fights are happening, not at the edges. The pardon power is obviously official. A private business transaction is obviously unofficial. At the center, in the contested territory where conduct that could be characterized either way becomes the subject of litigation. The Chutkan immunity ruling documented in this series found that specific conduct related to the January 6th events fell on the unofficial side of the line, that pressuring the vice president through private communications, coordinating with private actors, the specific conduct at issue in that case, constituted unofficial acts not protected by the 2024 ruling. That finding is in the permanent record. The case was dismissed after Trump won the 2024 election, but the Chutkan findings about what constitutes unofficial conduct are documented and available to future proceedings. The impeachment predicate does not require the official-unofficial distinction. The high crimes and misdemeanors standard in Article 2. Section 4 applies to all presidential conduct, official and unofficial, because impeachment is not a criminal proceeding. It is a political accountability mechanism that the founders designed to reach conduct that might evade criminal prosecution. And that is the specific gap the 2024 immunity ruling created that impeachment exists to fill. Conduct that is immune from criminal prosecution for official acts is still reachable through impeachment because the accountability the founders designed for the presidency does not have a carve-out for official acts. The document's central claim, now that a subsequent ruling confirmed this, may or may not be verified. The constitutional framework the document describes is real regardless. Something I want to address directly because the document raises it, and it is the part that most requires honest treatment. The claim that Trump's removal is now inevitable. It is not inevitable. Nothing in the constitutional process makes any outcome inevitable. The accountability architecture exists. The predicate is established. The constitutional tools are available. None of that converts to inevitable because the execution requires human beings to make political decisions in specific political environments under specific political constraints. 17 Republican senators. That number requires senators from states where the political cost of conviction is lower than the political cost of acquittal. Those senators exist in a specific political environment that November 2026 will define but has not yet defined. The document presents the trajectory as clear. I think the direction is documentable. The accumulated conduct, the institutional responses, the 5-seat majority vulnerability, but direction is not destination. A trajectory can be interrupted. Political environments change. The specific trigger that moves senators from their current position to 17 votes for conviction has not occurred in the documented record as of this commentary. What the 2024 immunity ruling's relationship to impeachment tells you is structural. The constitutional mechanism exists. It is not blocked by immunity claims. It is available to Congress whenever Congress has the political will to use it. Now, whether November 2026 produces that political will is the open question. The accountability record this series has been building is the evidence base from which that question gets answered. Each documented action, each court ruling, each resignation, each immunity order, each WPR violation, each congressional vote is a data point that moves the political environment in some direction. The direction has been consistent. The destination is November. The Sotomayor dissent is worth spending more time with because it describes something that I think most coverage of the 2024 ruling underweighted. She wrote that she fears for democracy. That is the language of a Supreme Court justice describing her assessment of what the majority opinion does to the constitutional structure. Not hyperbole for public consumption. A formal legal judgment by someone who has spent decades interpreting the Constitution about what this specific holding means for the country's constitutional future. Her specific concern was not about Trump. It was structural. If a president can commit what would otherwise be crimes, she used the example of ordering a political assassination, and claim immunity because the conduct can be characterized as an exercise of core commander-in-chief authority, then the accountability structure for the presidency has a hole in it that future presidents can drive any conduct through as long as it can be framed as official. That structural concern outlasts Trump. It outlasts this administration. It defines what future presidents can attempt. The accountability story this series has been tracking is in part about what the second term reveals about where the practical limits of presidential authority actually sit after the 2024 ruling. Now, each second term action, each challenged executive order, each WPR dispute, each contempt proceeding, is a data point about how the immunity framework interacts with the constitutional checks that were supposed to constrain presidential power. Sotomayor's dissent was about what the ruling does to those checks over time, not just in this case, across every presidency that follows. The impeachment dimension is where those checks remain intact, constitutionally, structurally, as a matter of design. What the accountability story is testing is whether they remain intact politically in the specific conditions November 2026 produces. Last thing, and it is the thing that keeps me coming back to the CBS clip rather than the Avatar content. We don't really know why. But we don't know why because with this shadowy process, the Supreme Court doesn't have to tell us. That observations about the shadow docket, about the opacity of emergency orders, about the court winning Trump more applications than predecessors in what Findu is the most honest analytical observation in the entire document. And it applies directly to the immunity story. The 2024 immunity ruling was a full merits decision with written opinions. We know exactly what it said. We can read Roberts' reasoning. We can read Sotomayor's dissent. The reasoning is in the record. The document's central claim is a subsequent ruling on January 10, 2026, specifically about immunity and impeachment-driven criminal referrals. If it exists in conditions of transparency that allow evaluation. If it exists as a shadow docket order without written reasoning, we are back in the same epistemic problem the clip identifies. We know the outcome, but not the reasoning. I cannot verify the specific ruling the document describes. What I can verify is the constitutional framework. And the constitutional framework is clear. Immunity from criminal prosecution for official acts and congressional impeachment authority are constitutionally separate. They always have been. Also, no ruling is required to establish this, though a ruling explicitly confirming it would be welcome clarity in a legal environment where the immunity doctrine's scope is actively contested. The contested territory is not the constitutional principle. It is the application of that principle to specific conduct in specific proceedings by specific actors making specific political calculations. That contested territory is what November resolves. The clip was right that the import cannot be overstated. The 2024 ruling defined the parameters of presidential power in ways that will shape constitutional law for generations. What it did not do is eliminate the accountability mechanism the founders built specifically for this kind of presidency. That mechanism runs through Congress. Congress runs through November. I'm David Harper. There's one more element worth naming before I go. The document describes Trump's social media response to the ruling. Combinares posting SCOTUS betrayed me, calling his own appointees part of the deep state, attacking the court that he spent his first term shaping. Whether that specific reaction is verified or not, the behavioral pattern it describes is documented across the accountability story this series has built. When courts rule against him, and they have repeatedly on tariffs, on deportation procedures, on immunity boundaries, on document production, the public response follows the same template. The institution is corrupt, the decision is illegitimate, everyone involved is part of a conspiracy. That template is analytically significant, not primarily as evidence of psychological distress. It is analytically significant because of what it tells you about the underlying strategy. The attacks on judicial legitimacy are not random. They serve a specific function, maintaining the loyalty structure's belief that any adverse ruling is invalid, so that the political cost of the ruling, equals in terms of Republican members' willingness to act on it, is minimized. If you can convince your base that the court is corrupt, you reduce the political permission for your party to respond to what the court says. That is why the attacks on the Supreme Court after an adverse immunity ruling, even hypothetically, are not a sign of panic. They are a sign of strategy. A strategy that has worked repeatedly. Attack the institution. Delegitimize the ruling in the eyes of your supporters. Reduce the political cost of Republicans defending the conduct. The accountability architecture runs through November because November is where the strategy either succeeds or fails. The base stays energized or it doesn't. The 5 seats flip or they don't. The permission structure for Republican senators either develops or it doesn't. Constitutional tools and political conditions. The tools exist. November determines the conditions.